Welcome to The Explainer, where we break down big topics. Today, we are tackling agency law, which sounds pretty formal, but it's really all about one simple question.
So when are you legally on the hook for what somebody else does? I mean, think about that. This is a question that could make you responsible for a contract you never signed or liable for an accident you weren't even near. Now, the answer isn't always obvious, but believe it or not, the way we figure it out is actually pretty clear. Okay, let's make this real. Imagine you ask your friend, "Hey, could you go buy that blue Honda Civic for me? Here's 25 grand." They go out and they do it. And just like that, you now own a car and you owe that money, even though you weren't the one who signed the papers. That right there, that's agency law in a nutshell. Your friend acted as your agent, and the law basically says their actions were your actions. All right, so let's put an official name on this. What exactly is an agent? Well, at its core, it's all about the legally recognized power to delegate something to someone else. The official legal term is a fiduciary relationship, which is just a fancy way of saying it's a relationship built on trust. And it really boils down to three key things. First, both of you have to agree to it. Second, the agent has to be acting for you, the principal. And third, and this is a big one, you have the right to control what they're doing. You put those three ingredients together, and boom, you've got a legal agency relationship.
Okay, now this is the absolute key to understanding all of this. You have to think of agency law as two completely separate worlds. It's like a video game with two different levels. In one world, you've got contracts. We'll call that the world of deals. In the other world, you've got torts, which are basically messes or accidents. And the rules you use for each world are totally different. Your entire focus changes depending on which one you're in.
So first, let's jump into that first world, the contract world. This is all about what gives an agent the power to lock their principal into a deal. When we're talking about deals, the whole game comes down to one single word: authority. Did the agent actually have the legal authority to make that deal? If the answer is yes, you, the principal, are on the hook. If not, you're probably in the clear. The most straightforward type is called actual authority. This is all about the communication that happens directly between the principal and the agent. So whether you say it out loud, send an email, or it's just implied by their job, it's all about what the agent reasonably believes they're allowed to do based on what you told them. But then you have apparent authority. And this is where things get interesting because the focus totally shifts. It's not about what the principal told the agent. It's about what the principal's actions led an outsider to reasonably believe. Think about a job title or a history of letting someone sign checks. The key communication here goes from the principal out to that third party. Let's see how this plays out in a real case. You've got this company, MX Technologies, and they have a 24-year-old events manager. She goes out and signs contracts for over $350,000. The company later said, "Whoa, no way, she didn't have the authority to do that." So the big question is, do they actually have to pay up? And this was a really messy situation. Internally, the company had a clear policy. Anything over 20 grand needed the CFO's approval. So she definitely didn't have actual authority. But from the outside, to the hotel she made the deal with, her job title was events manager. That looks like she has the power, right? That's apparent authority. Since the facts were all tangled up, the court basically said, "We can't decide this. A jury has to figure it out." It just goes to show you how critical the specific details are. All right, let's switch gears. We're leaving the world of deals and stepping into the world of messes. We're talking about torts now, civil wrongs, things like negligence and accidents. And in this world, we stop talking about authority. The key question is totally different. The core idea here has this old school Latin name respondeat superior. And all it really means is, let the master answer. And this is a huge deal. It means an employer can be held liable for the wrongful acts of their employee, even if the employer themselves did absolutely nothing wrong. The responsibility comes purely from the relationship. But, and this is a big but, this powerful rule only kicks in if two specific conditions are met. First, the person has to be an actual employee, not just any agent. And second, the wrongful act, the mess, had to happen within the scope of employment. So you see, our entire focus shifts away from authority and onto the nature of the relationship and control. And this right here is the big aha moment. Think of it like a spectrum of control. To be on the hook for a deal your agent makes, you only need a low level of control. Basically, just control of the overall mission. But to be responsible for a mess they make, the law demands a much, much higher level of control, the kind an employer has over the specific manner and means of how an employee does their job. That distinction is everything.
So now that we have our deals versus messes framework, let's apply it to stuff you see every single day, from fast food chains to the apps on your phone. So check out this famous case. A woman finds a sapphire stone in her Big Mac. Ouch. Now, this happened at a franchise McDonald's, which means it was independently owned, not run by the giant corporation. So the huge legal question became, can the massive McDonald's corporation be held responsible for the negligence of its franchisee? Well, the customer's lawyers argued yes on two grounds. First, they argued for actual agency, saying that McDonald's exercised so much control over the franchisee's daily operations, down to the exact food prep methods, that it created that high-control relationship. Second, they argued for apparent agency, because hey, from a customer's point of view, every single McDonald's looks and feels the same, so you're relying on the big company's reputation for safety.
And the court found both of those arguments were compelling enough for a jury to decide. This quote from the decision just nails it. It says that the very thing that makes McDonald's so successful, its insistence on uniformity, is what could also make it legally responsible. It creates this powerful impression that they are in control of everything. And this isn't just about burgers. This exact same debate over the level of control is at the very heart of the modern gig economy. Ride-sharing companies say, hey, we're just a tech platform connecting independent drivers with riders. But others argue that the company's control over pricing, policies, and who gets deactivated sure looks a lot like an employment relationship, which could make them liable for their drivers' actions. So, we've journeyed through the worlds of contracts and torts, deals and messes. What is the one thing you should walk away with that'll help you make sense of any agency problem? It all comes down to asking one simple question first. Is this problem about a deal or a mess? If it's a deal, your entire analysis should focus on the agent's authority. But if it's a mess, you have to analyze the principal's level of control over the relationship. Getting that first step right unlocks the entire problem. And that leaves us with this final thought. As our economy becomes more dominated by apps and algorithms that direct what people do, these centuries-old rules about control and responsibility are being tested like never before. It forces us to ask a really fundamental question. Who is really in charge here? And ultimately, who should be on the hook?